Retroactive application of Adam Walsh Act to offenders whose crimes predate law's enactment unconstitutional. Case number 2009-0088. State of Ohio versus George D. Williams, 12th District Court of Appeals, Warren County.
Today, this court must determine whether the state and federal bans on ex post facto laws prohibit the retroactive application of Senate Bill 10. My client, George Williams, stands convicted of one count of unlawful sexual conduct with a minor, the result of his admission and plea of guilty to engaging in sexual conduct with his 14-year-old girlfriend. Mr. Williams was 19 years old. And at that time, in May 2007, House Bill 180 required that, absent clear and convincing evidence to the contrary, a person convicted of this crime and under these circumstances must be labeled a sexually oriented offender. A sexually oriented offender classification requires the offender to report once a year for 10 years. Yet, through the enactment of Senate Bill 10, my client and others similarly situated are subject to more than double the length of their registration requirements. Under Senate Bill 10, not only have the temporal length of registration been enhanced, but also the severity and number of restraints attendant to that registration have been markedly increased.
So, counsel, are you bothered by the number of people that are going to know and verify that the defendant is a sex offender, a convicted sex offender, or the duration of the registration requirement?
The intense effects test has 7 factors, so none of those individual characteristics by themselves indicate that Senate Bill 10 has been transformed into punitive legislation. However, each of these factors taken together is what amounts to punishment.
If this law is applied to him, and I pull up the Warren County Sheriff's website, what will I see?
You'll see his name. You'll see his address.
And?
You'll see physical descriptions such as tattoos if he has any.
And?
You'll see the name of his employer.
And?
And I believe you'll see his address.
And?
You may see the name of the description of his vehicles.
And?
I'm not sure after that.
His photograph.
Yes, you will see a picture of him.
Yes. And that will go on for how long?
That will go on for 25 years, Your Honor.
It seems like the legislature has treated it exactly as that. It said, well, you gave us this much rope, let's see how much more we can take. And just keeps moving the ball on down the line and saying, oh, we can go back on this defendant, that defendant. They could start in on another type of crime and say, well, let's add a few more things that we want these people to do that they weren't told and wasn't a part of their sentence, but now let's tack it on.
The public information that is being grouped together and put on a website it's just, I guess, easier now for a member of the public to bring up Mr. Williams' name on the registry and then find all the information in one neat little package, as opposed to having to go look at, the docket or, any other search tool to determine where he lives, what he does, that sort of thing.
That's correct, Your Honor, but it was an innovation of in 2003, the website has been was in existence before Senate Bill 5. The same type of information was displayed. I think there's only been a few minor additions to the website after Senate Bill 5.
On July 13, 2011, the Supreme Court of Ohio ruled that imposing enhanced sex offender registration and community notification requirements included in the 2007 Ohio Adam Walsh Act against defendants whose crimes were committed before the effective date of that law violates Section 28, Article 2 of the Ohio Constitution, which prohibits the General Assembly from enacting retroactive laws. The 5-2 decision, which reversed a ruling by the 12th District Court of Appeals, was authored by Justice Paul E. Pfeiffer.